Good day everyone. For today's video, we are going to discuss Section 22 of Revised Corporation Code, Title 3, the Board of Directors, Trustees, and Officials. So in this video, we're going to learn kung sino or paano nga ba na-elect ang isang Board of Director or Trustees, its functions, terms, and qualifications. So let's begin with the correlations of the Board of Directors or Trustees, officers, and stockholders. So for easily understand my topic, let's first define each of one. Let's begin with correlations. Correlations mean the relationship or connection between two or more things, while stockholders or member refers to owners who have residual powers over fundamental and major corporate changes. When we say residual powers, it refers to a remaining power after the greater power have been delegated to the other authorities such as Board of Directors. Meanwhile, the Board of Director, he or she oversees the overall management of the corporations, while the officers are the people with day-to-day responsibility for running the corporations. So in this code, tatlo yung nabanggit na corporate officials, namely the president, treasurer, and secretary. So let's go back to my topic, the correlations of these three persona. So the answer is the correlation between these three persona is that the stockholders or slash members is periodically elect the board of directors or trustee, while in return, the board periodically elects officers. So mamaya we are going to know kung bakit they have elections for board of director or trustees. So next slide, the nature of powers of board of director or board of trustees. First is acts of management and ownership. When it comes to acts of management, we are pertaining to the board, and when it comes to acts of ownership, we are pertaining to the stockholders or member if it is a non-stock corporation. This is because the power or the nature of powers of board of director or trustee is very important in the sense that it is undelegated and original, meaning hindi mo lang siya basta-basta ipagkakatiwala kung kani-kanino lang. So the board should have enough knowledge and skills in running the corporations. Thus, the stockholders or members confer or give those powers to the board. Therefore, yung stockholders or members is only derivative as the owner of the corporations or the acts of ownership, and the power as provided in the articles of incorporations. Meron kasi tayong tinatawag na charter list kung saan andon yung mga dapat at hindi dapat gawin ng isang stockholders or members. Kasama na dun yung the board and the corporate powers ng isang corporations. So second one is where the corporate power resides. So once the election of the board of directors is done, the stockholder / member relinquish corporate power to the board in accordance with the law. Why? Because it is necessary for efficiency. As we all know, corporation can have tens or even hundreds of stockholders in which meron sila kanya-kanyang decision making kung saan this result for disunion or walang pagkakaisa ng isang corporation. Thus, the corporate power resides in a small and compact body at yun yung board of directors. The next slide, the limitation of powers of board of director or board of trustees. So what is business judgment rule? So here in the revised corporation code, the business judgment rule is called contracts intra vires. Intra vires is a Latin word of beyond the powers. So when we combine contracts and intra vires, that means the contract is made beyond the power. So sa madaling salita, the board of director or trustees step out the laid or imposed law by the constitution. So technically, kung iisipin natin, we could consider the contract is illegal. However, because of this judgment rule, we could not automatically consider the contract as illegal even if it is against the imposed law by the Constitution. Why? Because it is Why? Because the reason behind it is the laissez-faire rule. Laissez-faire rule is an economic theory that restrict the government interventions. So, naniniwala kasi ang mga economists na magiging best out of it ang economy or ekonomiya kapag less ang interaction ng government. So, sa madaling salita, the laissez-faire rule suggests to leave the business matters to the businessman. Kaya naman, the court will not interfere nor questions the decision-making of the Board of Directors or Board of Trustees unless otherwise such contracts are unconscionable or reasonable and oppressive as to amount to wanton destructions to the rights of the minority. So, next slide po. So, since the business judgment rule is a general rule, syempre may exemption yun, and that is the board shall exercise good faith. So, it is the fiduciary duty of the board of directors or trustees to exercise good faith, care, and diligence in the administration of the affairs of the corporation and protect not only the interests of the majority but also the minority of the stock. So, fiduciary duty, guys, when we say fiduciary, it refers to a relationship based on trust. That's why a board of directors or trustees is kinakailangan gampanan ang kanilang tungkulin ng maayos since pinagkatiwala ng stockholders na ang pamumuno sa kamay ng board of directors or trustee. So how about they fail to do their jobs or nagkaroon ng negligence in their work? So dito na pumapasok yung tinatawag nating derivative suits. Derivative suits is a lawsuit brought by a shareholder on behalf of the corporation against a third party. Often, the third party is an insider of the corporation, such as an executive officer or director. So, the derivative suits is used by the shareholders to enforce claims or shares against the wrongdoing of the board. So, for example, pwedeng kasuhan ng shareholders on behalf of the corporation ang kanyang mga board of directors or executive officers kapag nalaman nila na the board of directors or the executive officers use the corporation's asset for their personal use. So, mali po yun. And derivative suits, maliban doon, it is used include the actions to examine corporate books and records. So, that's the purpose of derivative suits. So, next slide is the content or yung article of Section 22, the Board of Directors or Trustee of a Corporation. So, hindi ko na po babasahin ang buong Section 22. Instead, let's proceed to its explanations. So, Section 22, Paragraph 2. So, the governing body of a corporation is, of course, the Board of Directors, since siya nga po ang responsible for the overall management of the corporations, and it is also stated in this code. So, the governing body of the corporation is the Board of Directors. So, the Board of Directors, sabi sa Section 22, Paragraph 2, the Board of Directors in a corporation is not more than 15. So, kung mapapansin po nyo sa Old Corporation Code, the minimum member of the corporation or the Board of Directors is 5 and maximum of 15. Pero here in the Revised Corporation Code, it is a 15 Board of Directors na. Kasi we have so-called one-person corporation. So, obviously, mag-isa lang siya. So, isa lang din ang Board of Directors. Second one is the Board of Directors should a owner of at least one share. So, So the board is required to have at least one share because of a pretty simple reason. Of course, when you have an investment inside the corporation, syempre you are devoted and putting more attentions to the stake para magkaroon ng gains ang iyong investment. So the third one is 1-year term director and 3 years term trustees. Exemption, principle of holders. So ang sinasabi lang dito sa principle of holders is kailangan maghintay ng director and trustee na magkaroon ng na ma-elect and ma-qualified yung kanilang successor bago sila bumaba sa kanilang termino. So, ibig sabihin, yung principle of holders maaaring mag-exceed sa 1-year term and 3 years term ang isang director or trustees kapag wala pang nai-elect and qualified for their successor. So, next one is not convicted by final judgment in certain cases within 5 years prior to elections. So, I would not discuss it any further because it is stated in Revised Corporation Code Section 26. But the general idea here is that the Board of Directors is not qualified if it is convicted or nakasuhan sa loob ng 5 taon bago ang elections. And the last one is our qualification provided in the bylaws. So, technically, these 4 bullet is the minimum requirement of the board of director in corporations. Pero kung merong other qualifications provided in the bylaws, so they may do so. So, ang ibig sabihin lang nito is, maliban sa 4 na ito, meron pang ibang requisites ang isang corporation. For example, the bylaws of corporation require the board of directors na magkaroon ng degree in particular course and so on and so forth. So, pwedeng mangyari yun. The next one is the corporation exercise its power through board of directors. So, this is true and correct since the board of directors was delegated for overall management of the corporations. Thus, the board shall exercise all power under corporation code. So, hindi ko na rin siya i-discuss kasi meron tayong separate discussions about it or yung tinatawag nating corporate power. So, mamaya we will discuss it in details. The next bullet is the board of directors shall conduct all business. So, here is the explanation of it, the authority of the board of directors. Ang sinasabi lang dito is that the board of directors or trustee has a sole authority or limited or it is only belong to the board of director or trustee to determine policies, enter into contracts, and conduct the ordinary business of the corporation within the scope of its charter. Example is articles of incorporations, bylaws, and relevant provisions of the law. So next one is the board of directors shall controls and holds all the property. So, we have separate discussion about it, but the general idea here, as we remember, the corporation is an artificial being in which it can have a name and can acquire or hold property. So, as a board, he or she controls and holds that properties. So, next slide is may corporate powers be directly conferred upon corporate officers. So, in Tagalog, maaari bang maipasa ng Board of Directors ang kanyang corporate powers directly to his or her corporate officers? So, the answer is the corporate powers may be directly conferred upon corporate officers or agents by statute. So, what do we mean by statute? It is a formal written law na binibigyan ng consent ng Board of Directors ang kanyang mga corporate officers or agents na i-exercise ang corporate power as long as it is based on the charter. Example is articles of incorporation, bylaws, or by resolutions, or other act of the board of the directors. So, the next one is the kinds of the corporate power. Ito na yung sinasabi ko na have a separate discussions about it. So, the corporate power is divided into three categories, namely express, implied, and incidental power. Express power is a power given by the statute and articles of incorporations, meaning express power are those powers na nakasulat sa statutes and articles of incorporations, while implied power is a power that is needed to accomplish the business purpose. So, kabaliktaran naman siya ng express power, in which implied power is not written in any kind of case or in any of statute or articles of incorporations. On the other hand, implied power are those powers that are not directly impressed in the articles of incorporations or by statutes for the officers or agents grant the business purpose. So last is the incidental power or inherent power. Incidental or inherent power are power in which the corporation exercised by mere fact of its being corporations. Since the corporation is an artificial beings, so meron yung inherent power or meron siyang power such as, example, power to sue and be sued, power to adopt and use a corporate seal, or power to acquire and convey property, and so on and so forth. So next slide, 3 levels of control. So ito ngayon sinasabi ko, ikatlong bullet of corporation exercising its power through its board of directors. So the board of directors controls and holds all the property. So there are 3 levels of control, namely the board of directors, second is the officers, and the third is the stockholders. So let's first discuss the board of directors. So the board of directors has a control on corporate policies, general management, and individual officers or agents. So corporate policies, it is indicated in the authority of board of directors or board of trustees. Check nyo na lang, nandun naka-indicate. And then second one is the general management. Since the board of directors or the board are responsible for the overall management of the corporations, so siya yung may hawak ng corporate powers. Next one is individual officers or agents. So the board of directors has a control in individual officers kasi siya yung may hawak or namumuno sa mga individual officers or agent. The next one naman is the officers. So the officers has a control in policies laid down by the board of directors. So since hawak lang sila ng board of directors, sumusunod sila sa mga policy na inilalatag ng mga board of directors. And the next one is wide latitude in determining business operations. Since kanina nga sa definition ng officer, they are responsible for day-to-day operations of the corporation. So dapat meron silang wide latitude or enough skills in running the business operations. So the next one is the stockholders has a power in residual power over fundamental corporate changes. So in the latter case, the board of directors could not act alone. So in the end, kailangan pa rin nila ng approval ng stockholders sa mga fundamental and malalaking corporate changes such as amendment of the articles of incorporations. So note, as a general rule, all corporate powers are to be exercised by the board of directors. Exemptions are made where the code provides otherwise. So the next slide is the power to decide whether a corporation can enter into a binding contract. So the power and responsibility to decide whether a corporation can enter into a binding contract is logged with the board of directors. So as a general rule, in the absence of authority from the board of directors, no person, not even its officer, can validly bind a corporation. So as I was said a while ago, na pwede or maybe the corporate power can confer to its corporate officers is pwede po yun. But when it comes to binding a contract, no person, not even its officer, can validly bind a corporations. So, malinaw po ba? And the next slide is qualifications of Board of Directors / Trustee. First is for a stock corporation, ownership of at least one share of the capital stock of the corporation in his own name. And for a non-stock corporation, only one member of the corporation can be elected. So, as long as meron kang one share, pwede kang maging board of director, and if member ka ng corporation, pwede kang ma-elect as a board of trustees if it is a non-stock corporation. Second one is the director or trustee must be capacitated. So since sinabi ko na rin to na the board or the power of the board of director is very important in the sense that it is undelegated and original. So dapat the board is fully equipped, have enough knowledge and skillful in running the corporation. The third one is the director or trustee must be of a legal age. So common sense na lang to na in binding contract, dapat nasa legal age na tayo. And fourth is other qualification as may be prescribed in the bylaws of the corporations. So, eto lang tatlo yung minimum requirements or qualifications of a board of directors. For the other qualification, it is prescribed in the bylaws of the corporations. So, next one is independent director. So, kapag sinabi natin independent director, it is a member of the board that aside from managing the corporation, wala na siyang ibang tungkulin or free from any or any other relationship. Meaning, meaning the independent director is free from material interfere. Kasi po, merong mga instances that the board can also be an executive of the corporations, or it can be elected as a president, treasurer, or a secretary. So in that case, hindi po yun pwede. Kasi in which the independent director must not have any material relationship to the company, not even a part of executive team, and not involved in to day-to-day operations of the corporations. So next one po is the board of the following corporation vested with public interest shall have independent directors constituting at least 20% of such board. So, sinasabi lang dito that a corporation na vested with public interest ay dapat merong independent directors or 20% of independent directors. So, paano po nangyayari yung 20%? So, nangyayari yun if, for example, yung corporation vested with public interest has a 10 board of director, itimes mo siya sa 20, so the answer is 2. So, at least 2 independent directors yung corporation vested with public interest na yun. So, ano nga po yung mga corporation vested with public interest? Sabi dyan, una, the corporation covered by Section 17.2 of Republic Act No. 8799, otherwise known as the Securities Regulation Code, namely those A. So, a corporation vested with public interest whose securities are registered with sector nakarehistro sa Security Exchange Commission. Pangalawa naman is corporation listed with an exchange or with asset of at least 50 million pesos. So, So, a corporation vested with public interest kapag meron silang 50 millions of asset. And letter C, those having 200 or more holders of shares, each holding at least 100 shares of a class of its equity. So, ang isang corporation daw po is a corporation vested with public interest kapag meron silang 200 or more stockholders that each of that is holding at least 100 of shares. Next one is a corporation that is invested with public interest if it is a banks and quasi-bank and SSLAs, pawn shops, corporation engaged in money services, business, pre-need, trust, and insurance companies and other financial intermediaries. So in short, lahat ng banks and quasi-banks and other financial intermediaries is considered as a corporation vested with public interest. And the last one is other corporation engaged in business vested with public interest, similar to the above or kamukha ng mga ito as may be determined by the SEC or Security Exchange Commissions. So, ayun po. So, that's all and thank you. Hope you learned something.